All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Judge Deb Sundquist presiding.
Thank you. You may be seated. Good morning. Today is Monday, August 17th, 2026. We are here today on one case. It is a petition to vacate presented by Mr. Darvell as a pro se litigant. Is that correct? We also have Ms. Parkhurst, correct? Ms. Parkhurst, have you appeared or presented before a court before? Right. Well, welcome. We are here today to listen to the Darvell versus Wherley Motors petition to vacate presented by Mr. Darvell, the employee. WC-26-6644 is the case number. Today, we are also here with two other judges on our panel. I am Judge Sundquist. To my left is Judge Carlson, and to my right is Judge Christensen, and we are here to listen to your petition, your argument, and then we will be the ones drafting the decision. As you know, each of you will have 15 minutes to present your argument. But Mr. Darvell, before we begin, I'd like to just speak to you directly. You have not retained a counsel to represent you today, is that correct? All right. And you are representing yourself in today's proceeding. Now, as a policy in Minnesota, we have fostered access to justice to all positions, and all positions have an opportunity to present their position, their argument, and to be heard. You are representing yourself today as a pro se litigant. So I'm going to explain some of the rules a little bit more clearly so you hopefully understand. And if you have any questions, please let me know. Yes. First of all, you will have 15 minutes to present your argument. The first 3 minutes, you will be speaking uninterrupted by the judges. And we want you to present your very best argument within those 3 minutes. After the 3 minutes, the judges, Judge Carlson and Judge Christensen, will both be asking you questions, as will I. Okay. And these questions are basically there to challenge your position. So we will want your best answers. Okay. What we'll want to hear today from you, sir, is to hear how this petition to vacate is different from the one that you submitted back in 2022. All right? Okay. Particularly, what are the material changes that have occurred since 2022, right? Ms. Parkhurst, the same for you. You have 15 minutes, of course. Mr. Darvell, if you would like to have some time for rebuttal, which is basically your response after Ms. Parkhurst is finished with her argument, you can reserve it, but we don't guarantee it because if the judges have a lot of questions, we might not be able to accommodate the rebuttal time. Okay? All right. With that, Mr. Darvell, if you are ready, you may proceed with your argument.
Since the last hearing, my shoulders have gone really bad. I need now to have reversals done. The last surgery, they basically did a salvage job. The doctors before that put 2 large balls into my total shoulder replacements. So when Dr. McCarthy did the last surgeries, he put 10mm size balls smaller into the shoulders. He also used cadaver parts to try to save the shoulders. It was not a fix. It did not work. So today I need to go in and have total reverse. The reason is because the doctors messed up. So now I'm looking at to have these, and in my exhibits, I put copies of the x-rays of the stem. It's basically down to here, it's cemented in, it needs to come out. He's very scared to do the surgery. He did one and it was nasty. He basically told me, and I'm sorry, my daughter was with me, it's gonna have to be done in a two-man operation and a 2-day surgery, a 2-time surgery. Because that stem's gonna have to come out and it's not gonna be pleasant, he said. I'm gonna break your arm. I'm gonna probably have to do a lot of bone grafts, and there's gonna be some screws, plates that won't have to stay, but they're gonna have to come out, and I'll go rebuild it in the second surgery in 8 to 12 weeks after. He says, plus we also have the issue of you have an RSD in your arms, so it's gonna have to be done at Abbott Northwestern Hospital, and he doesn't have a lot of surgical time there. And he also wants Dr. Buss, who is another renowned, very specialized shoulder surgeon down in this area. And he says, I need his specialty too to work on you. And then the other problem is I've got to have the other side done. So I'm looking at 4 operations, and I'm looking at one heck of a downtime and a lot of pain. My pain doctor wants to increase my pain medication, but she's scared if she does. I have the surgery. The anesthesists are going to have one heck of a time treating me with these surgeries because my body's going to be used to the pain medications and it's not going to be good. And another reason he wants to go to Abbott Northwestern, because there's one really good anesthesiast doctor there that knows a lot about RSD, which is very hard in this day and age to find doctors that know a lot about RSD. Also, I'm having a hard time getting the insurance company every time I go get my meds every month. I have to wait 4 or 5 days for them to decide if they're going to pay for my meds. So sometimes I'm 3 to 4 days waiting for them because they use this Carval or whatever, and then they decide they're going to do it. It is getting so frustrating. But it seems to come all the way back to when I signed this settlement, that when they found out I moved to Canada and that I had socialized medicine there, they've been trying 8 times. We have come to court. I've had lawyers go to court to get my medical benefits back. And there was a big one back in 2005. It was like $60,000 with the bills. And they wanted to offer me $5,000 to close out the medical. And I forget who the judge was, and come out and says, it doesn't happen. We don't close medical out. But they've tried 8 times, and twice we have come to this court to get them to pay the bills. And which you guys have ruled and said, hey, and one time you were quite mad that that was brought to this court. I'm ready for questions.
All right, thank you, Mr. Darvell. I have a question. I have actually a question about your kidney disease.
Yes.
So, you know, there's been a new rule that has been drafted and promulgated, and it's part of the rules in Minnesota, the Workers' Compensation Court of Appeals. It's Min Rule 9800.1100. This is new from when you were here before in 2022. And that rule actually, and I'll read it for you, states that where there's been a prior application to vacate the award, which is denied, which happened in your case, the application, this one here, must set out a concise statement as to the different circumstances supporting the current application. An application failing to meet the requirements of this part may be rejected under Minnesota Statute 176.275. So my question to you is, what can you say? What can you say here delineating exactly what has changed since 2022?
About the kidney disease?
About, yes, the kidney disease.
It has gotten worse.
Okay.
The blood tests have shown that my kidney disease is getting worse. The kidney doctor is saying that I'm about 1 step away from doing dialysis. And where I live, there's no dialysis unit, and I would have to travel from International Falls to Hibbing. And that's why in my brief or deposition, or what do you want to call it, that I wrote into the court, and I put what the cost of that would be. When I called him and asked, it was like $5,000 a day to get dialysis, which would be 3 times a week. Then I will have to have a driver and meal costs. So the extensive costs are going to be huge because there is no dialysis up in International Falls.
So you've been recommended to have this, but you haven't actually undergone
I am
dialysis.
borderline, he says. Like it could go like, and because of the medication I'm on for this RSD stuff could pop me anytime, he says.
All
You're
right.
that close.
Thank you, Mr. Darvell. Dr. Crossley, she is with the Essentia Health Clinic
Correct.
up in International Falls. She did write a letter indicating that you did have chronic kidney disease due to, at least in part, the anti-inflammatories that you're on to control pain.
Yes,
And she gave you something called a disability rating of 22%.
correct.
And in your understanding, is that new since the 2022
Correct. It
decision
is.
here? Okay. Who else are you treating with for that dialysis? Or
Pardon,
for
I
the,
didn't hear
who
you.
are you treating with for the kidney disease?
I'm also treating with a kidney doctor, Dr. Devante in the Duluth Clinic.
Were those records submitted with your petition?
Yes, they should be in the petition. Yes, Your Honor.
Thank you. Just a few more follow-up questions on the kidney disease. When was that first diagnosed, if you recall?
I can't answer that, Your Honor. I'm
Okay.
sorry.
And has the insurance company been paying for your dialysis or your kidney disease?
Yes, they have.
okay.
They've been paying for the blood tests and me seeing the doctor. I see him, the kidney doctor, once a year, and he's recommended that I get blood tests about every 4 months, which has been done up at the falls to save them expenses of me going to see him. But I see him once a year, and Dr. Crosley watches the rotten and whatever number that
All right.
what they're looking at.
All right. Thank you, Mr. Darvell. Judge Carlson, do you have any questions?
Thank you. Mr. Darvell, you did a, go ahead. You did a nice job in your petition and here today explaining your medical situation. I understand that your petition is actually based on 2 things. Number 1 being a substantial change in your condition since 2022. But you also talk about fraud.
Yes,
And I want to make sure that we address that. In your petition, you say fraud and lying were done by the judge, my lawyer, and the defense attorney. And in the context of what you're saying, you're referring to the 1986 proceeding. Am I correct?
correct.
Okay. And then you go on to say that you were not able to submit certain evidence back in for the 1986 proceeding. You listed job search logs, pictures, and statements from coworkers.
Correct.
Was there any other evidence that you feel that you were not able to submit back then?
What happened back then was, if I can be blunt and say, I went to court at the original date. The original attorney that was representing the insurance company had another hearing someplace and he went to that. And so they sent somebody else that date for the hearing. We had the hearing that day and everything went well. And they got another independent medical exam because they diagnosed me at the time at the thoracic outlet. It's like, so that exam was done. The record was supposed to be closed 3 months after that. There was no decision made. Nothing was happening. Almost a year later, I asked the attorney, what's going on? He goes, I don't know. We ain't getting nothing from Judge Bonovitz. And all of a sudden, he calls me into the office, calls me down there. And he says, well, I had a meeting with him. I said, well, what happened? I didn't get very good response. And then all of a sudden, about 3 days later, I got the decision and said there was a hearing. I said, well, I never got a notice of the hearing or that. Didn't hear nothing. I never was told.
Okay, and that's helpful because it's when we read the findings in order, it's a little difficult to figure out exactly what the timeline was, and we don't have well. And so let me ask you this, and I'm going to get you back to my question. You, again, in your petition listed a few things that you were not able to submit.
Right.
Is there anything else that you feel that you were not able to submit at the 1986? And I know the findings in order were, I call it the 1986 proceeding, but I understand it took place before then.
I had, basically the reason I said that was because back then there was a law that if you were under an apprentice program, your hourly rate, instead of me being rated at $4 an hour, I was working Monday through Saturday. I worked 8 hours a day, Monday through Friday, and I also worked 5 hours on Saturday. But being under an apprentice program, there was a Minnesota law saying if you were under apprentice program, you were supposed to be rated under this rate. Plus, I was also a school bus driver, part-time school bus driver. So none of this stuff got put into the system. So my hourly rate is not right,
Okay.
but I don't think it can be changed, and I'm okay with that.
Well, and so an allegation of fraud, especially for the purpose of vacating a prior decision or a prior award, there's a certain amount of proof that you need to make. So it's not necessarily an opportunity to retry the original case, but it's a different type of showing. So I understand your arguments that you feel like maybe a trial strategy wasn't great. So let me ask you this. When you say that there was fraud by the judges, the judge and the lawyers, do you have specific evidence of fraud other than perhaps some exhibits were not put in that you felt should have been?
Well, I was lied to. The judge screwed up, and he should have, second of all, he should have never heard the case in the first place because he played hockey at UMD with my employer. So he should have excused himself from hearing the case. Second of all, when he lost the file, if I would have been told that day, I would have asked the court for a mistrial to get a new judge and to hear this case with a different judge. But all three people knew that this was happening, and I wasn't told. None of this until years and years later when I met one of Mr. Ballmer's secretaries, and she told me what this happened. And then I finally stumbled upon it when I was reading one of the appeals court's decision, and it was in the subnote, and I put it through the rebuttal that look at the thing that it came up. So maybe it isn't fraud, but it's still, in my opinion, it's
Wrong.
kind of
Okay.
wrong here.
All right.
And I mean, if nothing can be happened, I'm okay with that.
Well, and I want to make sure that Judge Christensen has time to ask you questions as well. So I just want to ask one more time, do you have any specific evidence of fraud? I understand everything that you've said, but is there any evidence of specifically fraud?
Well, my wages are not right. So that's fraud. My wages are considered at $104 when I should have been considered at a higher rate of pay, which has infected me all the way to this day.
Okay.
My temporary total disability.
Okay.
Thank you, Mr. Darvell. Judge Christensen, do you have any questions?
Yes, I do. Thank you. Good morning, sir. So I'm just going to follow up with a couple of things. So as I understand it, at present, you're not on dialysis, though.
No.
You may be on dialysis in the coming months or years. Is that fair?
Yes.
And you're seeing Dr. Crossley, who we have a report from dated August 12th, 2024, and Dr. Avanti. Are they your kidney physicians? And then you mentioned this. Are you getting benefits at all or medical care and treatment in Canada?
When I moved to Canada to get my visa, I had to sign a document at the consulate here down in Minneapolis that I would not bill any of my workers' comp stuff to the Canadian Medical Association, or I would lose my visa.
And when did you move to Canada? Because we don't have that in the
Practically
record.
1987.
And then it in your petition, you indicated you're getting some kind of subsidies or benefits from the Canadian government. What kind of benefits or
My
subsidies?
wife gets, being I'm disabled, my wife gets a supplement from the Canadian government. I'm not entitled to it. She is.
Sure. And you know, is that a monetary benefit, housing benefit? What kind of,
It's kind of a monetary disability benefit because I'm disabled.
and how, is that per month, per week?
Yes, it is per month,
And how much is that?
like $450.
And I may have seen it in the record, but I can't recall.
I
off
don't
the top-
think I put any amount in it. I just said that she gets that
Okay.
that the Canadian government gives her some money for,
Understood. Are you receiving Social Security disability benefits now or Social Security retirement?
I am 65, so I think it transfers over to regular Social Security. I'm not sure of that, Your Honor.
And how much, month do you
They're
get?
$1,100 a month right now.
And that's all the questions I have. Thank you.
Thank you, Your Honor.
Thank you, Mr. Darvell. Looks like you have 9 seconds. Oh, in deficit, so you don't get any more time to speak, but we will let Ms.
Thank you,
Parker's-
Your Honors. I
Ye-
appreciate it.
Yes, you're welcome. Ms. Parkhurst, you may proceed when you're ready.
Thank you, Judge. Good morning. May it please the court. My name is Lauren Parkhurst and I represent the employer Wherley Motors and the Minnesota Insurance Guarantee Association. We are here today on the employee's third petition to vacate the December 2nd, 1999 stipulation for settlement and award on stipulation. The employer and MEGA respectively asked this court to deny and dismiss the employee's petition to vacate for 2 independent reasons. First, as a matter of law, this petition to vacate is procedurally barred by res judicata. This court and the Minnesota Supreme Court have already fully litigated and rejected these identical challenges. Under controlling precedent, the employee cannot continuously relitigate the same petition to vacate and medical records. Second, even if this court reaches the merits, the employee cannot satisfy the fondness factors. He has not demonstrated a substantial, unanticipated change in his physical condition or ability to work that was not explicitly contemplated when the parties closed indemnity claims 27 years ago. First, turning to the threshold issue of res judicata. On October 5th, 2022, this court issued a detailed decision denying the employee's prior petition to vacate. On April 4th, 2023, the Minnesota Supreme Court summarily affirmed that decision in its entirety. That mandate is final, absolute, and binding. Under Minnesota Rule 9800, 1100, Subpart 2, when a prior application to vacate has been denied, any subsequent petition must set forth a concise statement of different facts. The employee has failed to do so. In his petition to vacate, the employee points to additional surgeries and systemic complaints of kidney disease and low testosterone. But these are not recent developments. Every single one of those medical records existed before this litigation cycle and has already been fully adjudicated before this court and the Minnesota Supreme Court. While the employee emphasizes in his rebuttal brief that he may need complete revision surgeries of each shoulder joint, a recommendation for future surgery is not a substantial medical change under Sondrel. That is a continuation of a known progressive process, not statutory cause to vacate. This brings us directly to the court's controlling decision in Klonke. Under Klonke, while the statutory comparison window looks back to the original award, this court's prior findings of fact and legal conclusions from a prior denial are permanent and binding on the parties. The employee cannot use a 2026 filing to ask this court to act as an appellate body over its own 2022 decision or the Supreme Court's 2023 mandate, because he has presented zero new objective medical evidence demonstrating a physical shift since his prior petition. The petition is procedurally defaulted. Even if this court looks past the procedural bar, the record fails to support a vacation under the fondness factors.
Thank you, Ms. Parkhurst. Your 3 minutes is up.
Yep.
Ms. Parkhurst, would you agree that the kidney issue, the kidney failure issue, is a new issue that has not previously been litigated and not previously been presented before this court?
Respectfully, I would not judge. Um, The risk was explicitly recognized by Dr. Kaiser as early as 2004 when he ordered 6 months of renal monitoring. More importantly, this exact diagnosis was part of the record evaluated by the court in its prior October 2022 decision. The employee cannot relitigate a 2004 medical consequence when it has already been relitigated.
I'm sorry, when was it litigated? When was the kidney issue litigated?
In the prior petition to vacate, Judge.
I don't recall seeing that.
And I would also like to point out that Miga has continued to pay for his treatment related to his kidney disease.
I know that the low testosterone was argued, but the kidney failure?
Yes, so back in, it was part of the medical records, Judge, that were submitted.
Okay,
with the
so
petition.
it was in the medical records, but not specifically argued at that point.
I believe you're correct,
All right.
Judge.
All right, and how about the permanent partial disability rating? Had that been adjudicated or discussed at any point prior to today?
The claim that the employee has additional permanent partial disability was not a part of the prior petition to vacate.
All right, thank
Um,
you. Thank
But
you.
under case law, a additional permanency is not a reason alone to vacate a stipulation.
All right, thank you, Ms. Parkhurst. Judge Carlson, do you have any questions?
Thank you, Ms. Parkhurst. During Mr. Darvell's argument, he confirmed that he's actually bringing his petition to vacate on two separate grounds, one being substantial change in condition, and then also for fraud for the 1986 findings and order. Can you please address that, the fraud, please?
Yes, Your
And I'm
Honor.
sorry, the claimed fraud.
Your Honor, the employee is alleging fraud under the 1986 hearing, the findings and order. That was a fully litigated judicial determination issued over 40 years ago. The employee has submitted zero evidence showing that the judge's findings contained any fraud. Furthermore, any indemnity claims following that order were compromised and fully resolved under the 1999 settlement, setting aside the orders both legally unsupported and mooted by that settlement, and under the statute. A petition to vacate, it does not deal with fraud from the hearing, Judge.
Okay, and then I just have one question as a follow-up on the kidney issue. If this court finds that there's been a change with regard to the kidney disease, whether it's a new diagnosis or progression or permanency, is that something that we can decide, or is that something that we should refer to the lower court for further findings on the kidney?
My client has continued to pay for treatment at the present time related to the kidney disease. If a dispute arises over the reasonableness, necessity, or causal relationship of any treatment related to the kidney disease, the employee's remedy would be to file a medical request. It's vacating the stipulation is not the procedural vehicle to resolve prospective medical treatment dispute.
Is there any medical opinion or medical evidence that the kidney condition is not related to the work injury?
I don't believe so, Your Honor, which is why my client has continued to pay for it.
Okay, thank you.
Thank you.
Judge Christensen?
Yep, thank you, Your. My question is just following up on that. It looks, in terms of reviewing your response, the employer and insurer haven't made any primary liability determination regarding the employee's, Mr. Darvell's, kidney injury or alleged kidney injury. Is that correct?
Correct, Your Honor.
And you haven't done any IMEs or anything of that kind to assess the nature and extent of the injury, causation, or things of that kind, correct?
I don't believe we have at this time, Your Honor.
Um, But as I understand your argument today, the employer and Amiga have been paying for all of Mr. Darvell's kidney care and treatment. Is fair?
Correct, Your Honor.
Okay. And I know in terms of at least the past case, it looks like Judge Cannon back in 2018 found a causal relationship between Mr. Darvell's low testosterone condition and the work injury. Is that correct?
Yes, correct. And my client has continued to pay for anything related to that as well.
And I assume you've continued to pay all of his shoulder care and treatment with Dr. McCarty and his group.
Yes.
I think those are all the questions I have. Thank you.
I have a question, Ms. Parkhurst. You have seen Dr. Crossley's August 12th, 2024 letter indicating that the employee has developed chronic kidney disease due to, at least in part, the use of the anti-inflammatories that he had to take due to the pain levels he's experienced over the years, as well as a 22% disability rating. I have a question about foundation. What would your position be on Dr. Crossley's foundation? Did she have or did she not have foundation to make that opinion?
We're not disputing anything with foundation at this time.
All right, thank you.
Nothing else.
Any other questions?
Nope.
No? You may continue if you like. Go
Thank
ahead.
you. Analyzing the fondness factors, first as a change in diagnosis. The employee alleges that his bilateral shoulder condition has changed because he underwent post-settlement revision surgeries. And he also alleges medical negligence and the wrong-sized hardware. A progressive worsening of a known condition is not a change in diagnosis that allows us to vacate a settlement under the statute. As early as July 2000, Dr. Kaiser explicitly warned the employee he would face ongoing degenerative changes and would require future treatment. The employee acknowledged that risk, and the medical records specifically state that potential joint degeneration was the reason medical benefits were left open. As to the ability to work, the employee claims he is now 100% unemployable. The historical record demonstrates that this was his exact baseline at the time he signed the stipulation for settlement. On January 22nd, 1999, nearly a year before the settlement was executed, his treating physician documented that the employee was unemployable due to his upper extremities. The employee agreed at that visit, stating he did not believe he will ever work again. Under Minnesota law in Brunn v. Red Lake Builders, returning to a known baseline and ability to work is not a legal change in work capacity.
Ms. Parkhurst, I'm sorry to interrupt you, but I want to get back to something you just said.
Yes.
You indicated that kidney issues were a known risk,
Yes.
at least at the time of the settlement. Wouldn't you agree that something being a known risk still doesn't make it that it can't be a substantial change in condition? Just because you know something's possible doesn't mean that it can't be a substantial change in condition. Would you agree with that?
Under case law, a progressive worsening of a known condition is not considered a change in diagnosis. So he would need something greater than just developing a condition that he had known about.
Being required or being recommended to be monitored is different than having a stage 3 kidney disease. All right, you'll agree those are separate things.
Yes, Judge.
And at the time of the settlement, he didn't have stage 3 kidney disease, correct? So, okay, thank you.
As to medical costs and contemplation of the parties, the 1999 stipulation was a negotiated contract where the employee received $150,000 lump sum to close indemnity benefits, while future medical care remained open. As this court held in Burke v. Asphalt, the factor of costly medical care carries minimal legal weight when medical benefits are left open. MEGA has consistently paid and continues to pay for all reasonable, necessary, and causally related medical care. Should further treatment be necessary, the employee's remedy lies within his open medical benefits. It does not justify setting aside a 27-year-old full final indemnity settlement. In summary, members of this court, the employee has received the full benefit of his bargain from his 1999 settlement. The parties expressly contemplated that his shoulders would degenerate, he may need future surgeries, and that he faced ongoing wage loss. This is why medical benefits were left open. Because this exact record was fully adjudicated and affirmed in 2023, and because no new medical shift has occurred since this date, res judicata applies. The employer and MEGA respectively ask this court to honor the finality of the settlement and enter an order denying the employee's petition to vacate. Thank you.
Thank you, Ms. Parkhurst. Any other questions by the judges?
Yeah, just a quick question. What's your position on Mr. Darvell's fraud against apparently his attorney, the judge, and I know you weren't representing the employer insurer at the time, but the counsel for the employer and insurer.
Yes, my position is that that would be a separate issue under the findings and order that were issued with that hearing. And it is not a reason to vacate the settlement under the statute.
So if I'm following you, if there was an appealable issue, it should have been done at that time and not now.
Yes,
Thank you.
thank you.
Thank you very much, Ms. Parkhurst. Well done for your very first oral argument for our court. You may be seated. I'd like to thank both of you. Mr. Darvell, you did a very nice job. Ms. Parkhurst, very nice job. We have now concluded this hearing and the record is now closed. A decision will be filed within 90 days. Thank you so much.
All rise. Court is adjourned.